Honorable Hendricks, can you hear us? Honorable Nyatso, can you hear us?
Yes, I can. Sorry, Chair, I can hear you.
Thank you. Honorable.
Yes, Chair, we can hear you loud and clear.
Thank you. That's helpful. Honorable Jafta, can you hear us?
Yes, Chair, I can hear you.
Okay, thank you. I want to welcome all of you, honorable members on the virtual platform, now that we're connected with you, to welcome the public protector, as well as the legal team of the public protector led by Advocate Mkhofu, to welcome the evidence leaders, Awa and Mayosi, welcome members of the media with us, the entire support staff, as well as the members of the public who are rejoining us again to be part of the proceedings. Thank you. Welcome again, Mr. Koni. We continue with you. Now, without wasting any time, I'm going to take this time and ask Advocate Mkhofu to continue with you, as indicated, until tea time. Advocate Mkhofu, over to you.
Thank you, Chair. So there's a note that I'm missing. So if I don't, I'll try and find it while we're going.
No problem. Just sort it out.
Yes, I'll try to do it. If I can't, I'll ask for 5 minutes at the appropriate time. Thank you, Chair. Good morning, everyone. Good morning, Honorable Sokoni.
Morning.
Yes. Yes, yesterday I think we stopped around the time when we were talking about the 2020 UN General Assembly resolution, which, as I said, was the culmination of a series of such resolutions dating back to 1993, which dealt with the institution of ombudsman. I'm not going to take you through those various UN resolutions. There are quite many. You've mentioned them on page 1 and 2 of your statement. But just collectively, you would agree that they all map out a journey towards the internationalization or globalization of the work of the office. And the last one that I mentioned, which is 2020 December, specifically incorporates the Venice principles that you and I went through in some detail yesterday, correct?
Correct.
Right. Now, I just want to isolate a few of the, I won't go into as much detail as I did with the Venice principles, but using the OR Tambo declaration, I'll just, again, it's a similar exercise as we did yesterday. So the back of your mind is, I'll just isolate some of the principles. I might not refer them directly to what's happening here in this committee, because you might have missed some of the evidence. But when I do the argument for the members, I'll be able to demonstrate what conclusions I seek them to make as to whether or not South Africa is compliant with such instruments. Do you understand?
Yes.
All right. Now, if we can then immediately go to what we might call the African version of the instruments, as endorsed by IOMA. By the way, who is the president of IOMA?
The president of IOMA is the Ombudsman of South Africa, Public Protector, South Africa.
Yes. And we established yesterday that the signatory to the ALJAMA declaration is her predecessor, Advocate Mdntv.
Yes, that is correct.
Right. So can we then go to that document? We were at page 268. We had dealt with the most important standards, obviously, independence and autonomy. And I think that's what led us to all the other instruments. So if we can just then go back. Yes, we dealt 1.1 is the one that really permeates all the documents, independence, autonomy, and I think we went to town as to what the requirements of those two principles entail. So I want us to quickly then go through the remainder, and I won't read all of them, I'll just jump some of them. I'll read those that are relevant to what I will argue at the end of the case. All right. It's 1.2 says the institution should not be subject to the direction or control of any person or authority in the discharge of its duties. And I think you and I agreed that that is a restatement of the principle of functional autonomy.
That is correct.
Right. As it is also captured in our constitution. All right. Then at 1.3, it says the discharge of the Ombudsman mediator's function is subject to nothing but the law and commands and of his and her conscience. Again, I would, subject to your agreement, say that that's an expression of the wide powers that should typically be granted to those offices, correct?
That is correct.
And then here's an important one which relates to something we discussed yesterday as well, wrapping up. And this also shows as to whether our system complies with even the African instruments, let alone the other international instruments. It says the Ombudsman, I'll say the public protector, shall be immune from being sued or prosecuted in his or her personal capacity. And you described why that is important in respect of independence and protection from reprisals.
That is correct.
And so, what happens to a country like ours, which clearly does not conform with even the ALJAMA declaration? What methods do we use at local, well, let's say at continental level, maybe to persuade or to popularize these principles? Because in the heading, they are described as minimum principles. To me, that means, this is the barest minimum that you should comply with to be a compliant public protector, isn't it?
That is correct.
So, okay, I mean, apart from trying to have these principles adopted at the level of AU, because then obviously then compliance would be driven at that level. Is there anything at the organizational level that you do to, when you see that a country does not comply with some of this?
Yes, at the organizational level, ALJAMA level, when we are made aware of the fact that an ombudsman office is under threat, we do engage the governments and try to find ways and means in which we can help that government to ensure that the office of the ombudsman is allowed to function as it should. In the past, we had intervened in Malawi. And we had also intervened, I think, my memory bears me right, one of the West African countries, we had intervened to assist an ombudsman's office that was under threat.
Okay, good. And, well, something as serious as a public protector or rather a country that clearly does not confirm with the functional immunity and of either suing, and in this generically I include the issue of personal costs because it's the same effect really, paying of civil based financial or rather monetary punishment, or which is worse, immunity from prosecution. I told you yesterday that our public protector is actually facing prosecution right now for the CX case. Is that the kind of thing that you take up both at organizational level and at country to organization level?
Yes, exactly. That is the reason why we're even here in these proceedings. We had actually requested that we should be given a platform. And we thank you for that. Thank you to this committee as well.
I couldn't hear you. You just went low.
Oh, my apologies. I said this is the reason why the African Ombudsman and Mediators Association is here at this August hearing. And we would like to thank you for having given us this opportunity to be able to address this matter before this honorable committee.
Okay. Thank you. So by that, you mean that well, I suppose, I don't know how it's done in diplomatic circles here, but is there a formal way in which you can pass the message or through the chair to South Africa on those shows I found? Oh, chair, I found my notes. Yeah. I'm sorry.
I did not understand the question.
No, I was saying, apart from doing it through the chair and the committee as you are doing now, is there a formal way in which you can communicate those areas of non-compliance to South Africa?
We are able to engage with the government directly, but however, we believe that this opportunity that we have been given also allows us to address the government directly, and we trust that it will start a process of discussion and engagement as well, not only here in South Africa, but in other countries as well.
Yes. All right. Then, if we then go to the next page, 269, Seppo. One of your minimum standards is that I'm reading 3.3. The process of removal shall be on the basis of a just cause and shall be fair, transparent, and regulated by the Constitution, and preferably involve an independent body. That's one of your minimum standards.
That is correct.
Yeah. All right. Well, as far as fairness is concerned, you and I covered some of the issues, for example, issues of conflict of interest and so on, which clearly undermine the fairness of the process. But I want to talk about another aspect of fairness. If a process in a country could be shown to refrain, or let's say where there's a refusal to call essential witnesses or relevant witnesses or witnesses that are specifically mentioned in the charges, thereby depriving the accused person, quote unquote, of an opportunity to absolve themselves. Would that be fair?
Repeat the question, please.
If a process in a particular country involved the refusal to call essential witnesses or relevant witnesses that are specifically mentioned in charges, thereby denying the accused person an opportunity to clear their names, would that be in conformity with 3.3, standard 3.3?
It would not be in conformity with the fundamental principles of natural justice, because that is our ultimate tool that we use as ombudsman officers. So a person's right to be properly, firstly, to be properly represented, secondly, to be able to properly defend themselves, should be respected and upheld in any constitutional democracy.
Thank you.
Yes.
And well, if it goes even further, and in a process where an ombudsman is in jeopardy of losing her job and position, and in that country, then there's a refusal to even call the complainant, the person who actually started the whole thing, to clarify what they had in mind and all the issues that you and I have traversed for the past hours. Could that be fair?
The complainant in any case is the one who brings the case before any court or any tribunal, and that is where the whole gist of the matter is based. So the complainant has to come forward and say, "This is my case." Otherwise, there's no case at all.
Thank you. Thank you. And but more importantly, for your purposes, if there was a direct refusal to call the complainant, would that be in compliance with minimum standard 3.3?
If there was a direct?
If there was a direct refusal to call such a complainant in a particular country, would that be in compliance with regulation 3.3, or rather minimum standard 3.3?
No, that would not be in compliance.
All right. Okay, then let's go to 4.2. Minimum standard 4.2 says the term maladministration should be given a broad interpretation as possible, or rather, yeah, I suppose it should say as broad an interpretation as possible, covering all public offices, institutions executing public functions, and institutions or individuals administering public funds. Now, this one is a statement, again, it goes to how wide, and I think our own court in EFF versus Nkandla, rather in the Nkandla case, also known as EFF versus the Speaker, spoke of very wide powers. So am I correct that this is also an expression of the width of the mandate?
Yes, definitely, that is so. It's very, very difficult to restrict the term maladministration. I've often said that the categories of maladministration are never closed.
Yes.
You know, because really sometimes it's really personal. how a person has been treated, because maladministration includes issues like rudeness, discourteousness, and depending on the type of industry that you are dealing with, the specific institution that you are dealing with, the concept of maladministration may change. So that is why the ombudsman is granted such wide discretion to investigate public service institutions to ensure proper, efficient, and effective service delivery to the people.
No, thank you. Yes, no, that's true. That's my favorite standard in Section 6 is that one of rudeness, because I think it shows how wide the mandate is. Now, in other words, if a public official just doesn't greet you when you greet them, you could report them to the public protector, theoretically, correct?
Theoretically,
yes. Yeah. However, one of the issues on a more serious note in South Africa is that even the courts have tended to trying to put this nicely, to restrict the deliberately wide mandate of the public protector. Yesterday we spoke about the 2-year limit issue and how it has been interpreted by our courts as if it was a prescription provision, and we clarified that that is not what it's supposed to be. But let me just give you another example. We have one of the cases that feature in this matter. We have a person who was the deputy president of the country and going towards a conference to make him the president, to cut a long story short. And it turns out that he received anything between 300 million and R1 billion from unknown sources. But the courts interpreted that to say no, even though the person holds those positions, that those billions or those hundreds of millions were given to him as a person.
Chair.
Just suppose Advocate Mbofu. Advocate Bauer.
Chair, I'm going to object to the characterization of what Advocate Mbofu is putting, because he must either stick to what the case was about and phrase it in a manner where the court says who the money went to and what the money went to, because he must tell us what he's talking about.
Advocate Mbofu.
Yeah, okay. Just answer. That's what I'm doing. I'm telling you what the case is about. I'm saying the case was about a person who is a deputy president of the country. Which part of that don't you understand?
If you're referring to the Busasa CR17 case, Advocate Mbofu, then say so.
No, I don't want to say so. I'm just giving an example of a situation, because the idea is not to discuss a particular case. It's just to get a concept.
That's fine.
Yeah. Thank you, sir.
But Chair, for purposes of cross-examination, Advocate Mbofu is saying we have a case, and he puts certain facts to the witness, which in our view is not necessarily and hasn't always been in sync with the case.
Can you agree that at this point he's putting forward general points?
Yes.
We're not getting into specifics.
Thank you, sir.
And hence I would protect that I don't find an issue if a name is not mentioned.
Yes.
Can we leave at that at this point?
Thank you, sir. Yes, and I'm deliberately leaving out the names. And if Ms. Bauer, when we argue the case, if I've put the question in such a way that it doesn't elicit what I need, she should be happy, because then she can say that it was just a non-question. Yeah. If a person who holds the position of deputy president and is involved in a process which is intended to elevate him to the presidency itself, and in that process receives hundreds of millions of whatever currency, the public protector then does an investigation and finds that there was something wrong with that in terms of the conflict and non-disclosure laws and all that. And I'm dealing here with a specific issue about how wide the mandate is. So I'm not really so much dealing with the merits of that case. I'm saying that in those situations, would it be in your understanding of the prescripts, both the international and continental prescripts, would that be in conformity with the very wide mandate to then say, no, even though we all know that this was done in the context that I've described, but the money was received by the person as another entity, like as a private person, and therefore the public protector must be barred from investigating such a, would that be in the spirit of the wide mandate of the public protector?
I'm not very familiar with the facts of the case,
No,
but okay, what I would say is that if that person is a public officer and falls within the mandate of the enabling legislation for the ombudsman to operate, then there should be no reason. There's no public officer who is exempt unless it is, for example, without jurisdiction. You may not investigate the judiciary or the legislature. So if it goes that far, then then the ombudsman cannot. But if it is within the mandate of that ombudsman, I don't see the reason why they should be blocked from investigating the matter. But I will go further to say the situation that you have actually referred to, if it was under my jurisdiction, I would pass it on to the Anti-Corruption Commission.
Yes.
Yes. So this is what we have been saying, the problem of multiple mandates.
Yes.
Where the ombudsman has got these multiple mandates, and then the difference between maladministration and other areas becomes mired.
Yes. No, that's correct. Actually, incidentally, it's interesting that you should say that without being familiar with the facts. That's exactly what the public protector sought to do, to refer it to the anti-corruption bodies. But thanks, you've answered my question as far as the it relates to the ALJAMA principles. Yeah. And well, just out of interest, that happened in a particular court setting or division of the courts. But when the tables were turned and that same person was now charged as a person, the court then said, well, now he should be here as a president. So I don't have to bore you with that, but that's what we have to deal with here. If we then go to number 7, so that's the next page, yeah. Okay, conditions of service, we spoke about that yesterday exhaustively, so I'll jump that. Right, okay. So those were just the things that I needed to clean up on the ALJAMA principles. Thank you, Chair. All right, can we then move to reprisals we've dealt with, rudeness we've just dealt with now. All right, let's then go to the speech. Page 331.
Statement or speech?
331. The speech of Honorable Sokoni to on the 21st September 2021. It's the one that was filed twice by us and by Ms. Bauer.
Tell you we're struggling to find it. Can you just be specific? Which item exactly? 3?
I don't know. It's 331 on the big page, on the same series that were.
Bundle H.
Yeah.
But which item?
Your team uploaded it via item numbers. Could they maybe assist you to tell you which item number it is?
Yesterday, which is 51. I'll get you the item now. It's it's bundle H, item 31, and and this page 331.
There's 15 sub numbers in bundle 31. Can you tell us what it's called?
Okay, why were we able to find these page numbers yesterday, the whole day? Page 331 of the same series we were using yesterday. If I just said page 269, for example, for the OR principles, so it's 331, just 30 pages after that.
It's called OR Tambo. That's where you can find it. But if you're not referring to it by a name, then she can't find it.
12 item.
I'm told it's item 12. Thank you. Right. Okay. Just move it up or down or whatever. Let's see more of it. Yeah. All right. That is a speech that you delivered. I'm just trying to move fast because of time so that we cover this. That's a speech you delivered on the 21st of September 2021. It's headed a paper presented during a facilitated discussion of AOC and AOMA by Her Excellency Mrs. Caroline CZ Sokodi, Public Protector of the Republic of Zambia. I'll take you through some of the key propositions that we make there, which are relevant to the discussions we had yesterday. So I won't dwell much, but I'll just highlight those sections. And if you care to comment, I'll ask you to. All right. Can we go to paragraph 2, or rather the next page? Yeah. The second paragraph is not numbered. Yeah. Okay. Further down. Okay, that paragraph makes the link that you were just making now between maladministration and corruption. Because as we said, maladministration is such an elastic concept in this field that, as I said, it starts from such things as not greeting to like corruption probably involving hundreds and millions of rands or dollars or whatever.
That is correct.
Yeah. Okay. And you make the point in the middle of that paragraph that maladministration may be termed petty corruption simply because of some of the activities such as discourtesy, to give just one example, have negligible effects on the government's resources. However, in terms of the law, maladministration is as much an offense as corruption, and more so because it creates obstacles to equal access of services and benefits of these services to all. And I'm linking this to the quest, really, in all the instruments, to say either, and by the way, I want you to comment on the, I think it's a statement from your affidavit or the annexure there too, about the need either to move away from the so-called classical model where the public protector's mandate is confined to maladministration on the one hand, or, which is what you and I are discussing now, to define maladministration as widely as possible. Is that generally the trend?
Generally, yes, most, well, it's not most, the countries which have multiple mandates really are in the minority, but the trend is that is that of embracing the broadening of the definition of maladministration.
Yes, and just referring that to where we started about the United Nations, and I want to correct me if I'm wrong on this. That trend of widening the scope of operation of ombudsman has gone so far to the extent that the office of the ombudsman, I mean in general terms, has now been welcomed, quote unquote, into the UN human rights institutions family.
Yes, in actual fact, in Europe, most of the ombudsman officers have got the single mandate of investigating human rights.
Mm-hmm.
Yes.
Okay, good. All right, then let's move on to some of the highlights of your speech here. Okay, on page 333, you make the point about conditions of services being similar to those of the judiciary. We discussed that yesterday, so let's jump that. But more importantly, again, to relate it to our situation, you say in the second paragraph, further down, the position of ombudsman has therefore been equated to that of a high-ranking judicial office or of a judge, with all the accompanying powers of the office except the power to make binding decisions. The position has also been vested with the conditions of service and remuneration of a judge. And I think you and I agreed that that would mean then generally that, for example, the suspension of a public protector should follow the same steps as the suspension of a judge.
Yes, exactly.
Thank you. Okay. And it also means that, as we demonstrated yesterday, at least from a constitutional drafter's point of view, the constitutional protections afforded of a judge to a judge are identical to those afforded to the ombudsman, correct?
Correct.
Right. Except, of course, for example, that a judge has security of tenure for life, whereas we've agreed that in the case of a public protector, it might be limited.
Yes, definitely. The judges have security of tenure for life. However, for the public protector, it's supposed to be for a term certain. So the ombudsman could have the same terms and conditions of service as a judge, but upon retirement, they would then maybe have some gratuity or something, some package given to them.
Yes.
Yeah.
Yes. Well, exactly. Well, some elements in this country look at that as if it's just a gift, a birthday present. It's as much misunderstood as the payment of charges for life. There are people who think that that's just, extravagance or largesse, and are not able to link it to the issue of independence. And you can confirm, I'm sure, that as someone who has even been nominated to be a judge, that the reason why judges are paid for life is not for fun. It's actually a very serious matter of ensuring their independence. It's actually to protect the public.
Yes, exactly.
All right. Then you discuss okay. You then deal with the comparison with the case of Indeni, which we discussed yesterday, where your court, in my respectful submission, wrongly relied on our case of Minister of Home Affairs, besides the public protector, basically to say that the powers were not binding, even though your constitution, unlike ours, specifically says that the powers are binding.
Yes, that is the reason why that case was so unique, and I had to mention it that
Yes.
in the Zambian constitution, the public protector is imbued with the powers to make binding decisions. But however, based on the judgment of the South African courts, where they stated that the binding powers of the remedial action reports of the public protector were not absolute, so they based their own judgment as well on that very judgment. But for me, it was something strange because here in South Africa, the public protector was imbued with binding powers by courts. It's not stated blandly in the Constitution. So this is the reason why I made that comparative analysis of the two cases.
Okay. And maybe in fairness to your court, then the issue, or rather, you know the case better than me because you were a party to it. I would say that if you compare it with our situation, if the court, if the issue was the reviewability as such, as opposed to the binding or non-binding nature, then obviously your case, your courts, constitutional courts would be in conformity with ours, in that in our situation, irrespective of the binding or non-binding debate, it's always been understood that the decisions are reviewable.
Maybe what I could just add as well is that the fact that the institution of the ombudsman is only encouraged to make recommendations. It also protects the courts from making conflicted decisions. So it protects the ombudsman from being placed in a situation of a compromised position. And it also protects the courts. They don't have to go over backwards to try to protect anybody just because there is some sort of influence, external influence to say, no, this such a decision would not be becoming for a member of the executive.
Yes.
So,
thank you. And then in your speech, you make quite interesting and detailed analysis of some of the cases that you say are relevant to the, some of the South African cases that you say are relevant to your topic, but also to the, what I've called the central thesis really of your evidence, which you've just mentioned about the recommendation versus binding nature. And at 336, you deal with the case that, for all intents and purposes, was a turning point in South Africa, and as I understand it from what you're saying, also in Zambia, which is economic freedom fighters versus the Speaker of the National Assembly, to us known as the Nkandla case. Starts with similarly, that's You see there, you refer to the Nkandla case.
Correct.
And and you observe there that that case was a turning point in the manner that I've described. But in the previous paragraph, just the last sentence, sorry, please just go back a bit. Yeah. You make the observation that the institution, because of this, now must budget for litigation costs as a matter of priority. Would you agree that that's one of let's assume unintended consequences of having the binding model? Is that then the cost of litigation automatically shoot up, because obviously people are more likely to challenge decisions that are binding than those that are recommendations?
That is correct. Although I must confess, within the office now, you know, we have actually raised our standards very high, because whatever evidence we get, we interrogate each and every piece of evidence thoroughly. Because, you know, we know that when this report comes out, you know, there's a possibility that it might be taken to court. So it has made us a little bit more cautious. It takes us a little bit longer now to issue a report, because we have to really do our due diligence and really interrogate our cases so thoroughly.
Yes, and in a way, you get what in English is called the short end of the stick, because your decisions are as binding as those of judges, but judges don't get reviewed, and you do.
That is correct.
And as we established yesterday, a judge can have all sorts of scathing remarks made about them in a higher court, but nobody's going to say they must come here and be impeached.
That is correct.
All right. Then you refer to another case that's relevant to this inquiry directly, which is the Reserve Bank of South Africa, or Public Protector versus South African Reserve Bank, otherwise known as the CX case. Yes, you summarize the facts of that case at page 337, and you point out that that report was issued after the Nkandla judgment, and that's quite important, because again, the reason why there was the hullabaloo was because of the binding nature of the decision. Yeah, and this is an example of what you and I spoke about regarding this so-called elevation of Audi, or the refusal of Audi into bias. You quote there from the minority judgment of Chief Justice Mkhwebane, and this was the sharp distinction between the two judgments, is that Chief Justice Mkhwebane was not necessarily uncritical of some of the things the public protector was accused of. But his point was that, well, to err is human. I think those are the words that he actually uses. And therefore, that should not be a basis for mulcting the person with personal costs and all sorts of things. And you indicated yesterday that yourself, you associate yourself with the minority judgment, the approach taken in the minority judgment of the Chief Justice. Am I right?
As I stated before, of course, being an ombudsman, I would think that the ombudsperson must be given the necessary protection. That companies doing the sort of sensitive work that they do, that is that of investigating the executive. So having personal costs being occasioned by the ombudsman, asking the ombudsperson to pay the costs of a respondent institution means that the respondent institution has gone round through the back door and managed to punish the ombudsperson for making a finding against them. So it should be directed at the institution, not at the person, because we're all human. You know, we do make mistakes in our jobs. But if at each and every turn that we make mistakes in our job, if a doctor is operating somebody and that person dies on the operating table, and then the relatives take the hospital to courts, and then the court says, no, the doctor has to pay in his personal capacity, you know. I mean, how many professionals would be able to do their job?
Yeah.
So basically.
Thank you. And I think Justice Mkhwebane makes that point, that it would have such a chilling effect that, quite frankly, and these are my words, nobody would ever want to be a public protector, because he says it should be just to bankrupt the person, basically. Because if you accept that the people that you investigate are normally the powerful in society, whether they are members of the executive, if they are members of the executive, it's even worse, because sometimes they even use state resources to fight you. Or there might be big banks or whatever, people with deep pockets. And therefore, it would be likely to bankrupt a normal human being if you have to pay costs for those types of institutions.
Yes.
And I think the gist of what you are saying is that paragraph 46 of that judgment, which you'll find at bundle C, item 3, number 17. No, this is country. Number 37, yeah. Bundle C, item 3, number 37. Paragraph 46. I'll just read it to save time in the meantime, but it will be put up. He says, all this was for a good reason. He says that's why personal costs against public officials is what you call a rarity. Public office bearers must be allowed the space to be human. I think that's one of the most profound statements which, if not neglected, would have probably made sure that we're not sitting here today. It says, public office bearers must be allowed the space to be human, and to err is human. It ought to take much more than ignorance, limited competence in one's area of responsibility, poor judgment, or incidental but harmless unfairness to others to order personal costs against an office bearer litigating in a representative capacity. And does that capture more or less what you are saying about the inequities of this practice?
Yes, that is correct.
All right. Now, we will have debates, no doubt, between us and the evidence leaders and others who are that way inclined towards the other issues raised about recommendations for constitutional amendments and so on. I'm just raising these issues now in the narrow space of independence, autonomy, unfairness, and cruel punishment towards a public protector. Now, Chair, if I may, then move to the other case that we touched on, which you referred to in the context of the wide mandate as to whether the public protector should have access to tax records and so on. You remember that case we spoke about? That's Public Protector versus Commissioner for South African Revenue Services.
Versus Commissioner
of South African Revenue Service.
Yes, I recall.
Now, I want to deal with that case, but not what we discussed yesterday. A separate issue now related to what we're discussing now. And that one, Tsepo, is at panel C, item 3, number 17.
Just for the record, Mr. Advocate Mpofu yesterday talked about this case at the level of generalities in respect of the subpoena. To my recollection, he didn't refer specifically to the case, or the witness didn't refer specifically to the case. Advocate Mpofu put the issue of whether subpoena should be issued by the public protector against personal information and whether she should be entitled to it. I just want to say that the witness did not testify specifically to this case yesterday.
No, that's not true. The witness spoke specifically about this case. She even said that she was surprised that she even pointed something in the case that I had forgotten myself. She said that in the case, the court had said that the public protector had other alternative ways, including approaching Mr. Zuma for the documents, and she had something to say. Nobody could make that remark if they were not talking about this case. As I say, I argued the case in the Constitutional Court, but I had forgotten that aspect of it. So she obviously was talking about this case.
I'm happy to accept I'm wrong. Sorry, I'm through you, and I'll deal with witness in the same.
Yeah, thank you.
All right, I thought that would be the point that you would you online to come to deal with that.
Yes.
Both.
Yeah. I mean, okay, I don't want to waste time on this, but just to illustrate the point, the point that the witness spoke about, you'll find at paragraph 4, where the court says, therefore, the public protector is entitled to subpoena taxpayer information. On the basis of this opinion, the public protector issued a second subpoena still requiring production of former President Zuma's taxpayer information and so on. That's what we discussed yesterday. But that's not what I want to discuss today. I want to take you to the issue that is related to what we have just discussed around the Reserve Bank case. And Chair, if I beg you to give me just an extra, whatever you are going to give me, an extra 10 minutes, because I need to read some of these. For me, this is something at the heart of what we're doing here. And something that actually, as I think I've said this before, it was a pleasant surprise. Because when we argued this during the case, we were even cautioned by the court that we were moving on thin ice as to the level to which we were criticizing the judiciary. But fortunately, we did so, and then the judgment vindicated us. And this relates to one of the 14 issues in the IOI guidelines, which is where the judiciary, I said yesterday that the judiciary and the legislature and the executive are supposed to play a role that is checks and balances rather than ganging up against the public protector. And I think we all agreed on that. But we put forward to the Constitutional Court evidence to show that our courts had actually gone overboard in melting the public protector with costs. And although the court didn't use the word fashionable, which is what I had used in my argument there, it basically vindicated that stance. And I'll read from paragraph 42. So that, did you find it? Okay, can we go to paragraph 42? I think that everyone talks about EFF and Reserve Bank, but I think this is their judgment that really defines what a country should not do. Yeah, okay. This is what Madlanga J said. And incidentally, he's the one who had questioned me in court about this. So I was very happy to see that between that time and writing the judgment, he probably looked at the evidence more carefully. It says, there appears, he says, in the middle, there appears to be a developing trend of seeking personal costs in most, if not all, matters involving the public protector. In other words, litigants were now catching on to this fashion, and they basically wanted to cash in, as it were. And it says, of these, a total of 4, including this one, have reached us. And the 3 high courts, in the 3, the High Court granted personal costs against the public protector. What one of those cases stand out was, what made one of those cases stand out was that a personal cost order was granted based on, quote, the usual rule. And that's what I meant by it's fashionable. That costs follow the result with no consideration whatsoever to special circumstances that justify the order. Okay. Then this is a far cry from the stringent terms towards of personal costs. And sorry, the next passage is more important for a different reason. This whole issue of so-called scathing remarks. The court in that case had made probably the most scathing remarks and found adjectives that I didn't even know existed to describe, to justify the personal cost order. And then this is what the Constitutional Court said. And in the matter instant, in this conclusion, the court has carefully selected and used epithets and particular nouns that are suited to award of personal cost orders, but there's not a scintilla of evidence to support those epithets and particular nouns, and therefore the conclusions. Thus, the conclusions simply cannot stand up to scrutiny. Then he says, out of the 4 applications that have landed here, it is only in one that this court has sanctioned the personal cost order. Of course, that does not mean that litigants who, on cogent grounds, believe that they are entitled to award personal costs against the public protector must not push for such awards, and that where such costs are warranted, courts should not grant them. But, he says, it does mean that courts must be wary not to fall into the trap of thinking that the public protector is fair game for automatic personal cost awards. And I just want to pause there. So this was a serious statement made by the Constitutional Court of, when you say automatic, you literally mean like just knee-jerk. So it's a public protector, therefore it means personal cost. And it says very important, whether inadvertently or otherwise. In other words, this could be in an innocent thing, but it could also be deliberate. I don't think it can be more serious than that. Whether inadvertently or otherwise, the High Court judgments in the EFF versus Gordon matter, and that in the instant matter are instances where the High Court fell into that trap of knee-jerk or automatic cost orders. And then he says, personal cost orders may have a chilling effect on the exercise of the public protector's powers, including litigating where necessary. And I think that's the point you're making about it would make a public protector not want to investigate because they think, well, if I'm going to be in for personal costs, then I might as well not even do the investigation. Correct?
Correct. And it also erodes the respect for the office, because this public protector is going to leave that court having personal costs awarded, against them. And then they have to go back and sit and call other respondents institutions to appear before them. There's just no respect for the office anymore.
Right. Then the learned judge says, has an office specially created together with other Chapter 9, others under Chapter 9 of the Constitution is an important cog in our constitutionalism, as it and the others were created, quote, to strengthen constitutional democracy. Axiomatically, the Public Protector's Office is more important than any incumbent. In other words, your personal hatred for a particular incumbent should not destroy the entire institution forever. Amen. Okay. And then he says, the impact of certain types of conduct that shake its operations as foundations may outlive the term of office of a number of incumbents. Needless to say, as the judiciary, we must not be guilty of contributing to the weakening of that office. The point you made yesterday that sometimes the judiciary itself becomes, quote unquote, part of the problem or part of the forces that threaten the existence of the office.
Yes, exactly. It's even mentioned in the Danish principles that the judiciary could be one of the institutions.
Yes.
Also.
And this is where I said you were using the words of Justice Matlanga when you said it would weaken. Yeah, because he says, quote, you weaken it, you weaken our constitutional democracy. Its potency, its attractiveness to those it must serve, its effectiveness to deliver on the constitutional mandate must be preserved for posterity. And I just want to refer this back to when he talks about effectiveness. Remember that the full name of the O.R. Tambo Declaration is the O.R. Tambo Declaration on the minimum standards for an effective ombudsman institution and cooperation with the African Union on strengthening good governance. So this issue of effectiveness that the learned judge was talking about here also captures what we call the minimum standards.
Yes, it does.
Yes. And here's the punchline. He says that I voice these words of caution, which I hope everyone would listen to. Says, because of the disturbing frequency and regularity of applications for and awards of personal cost orders against the public protector. Disturbing frequency, automatic. And then it says, what is particularly disturbing is that it is clear that the applications and awards are not always justified. That much is apparent from the facts that 2 out of the 3 personal cost awards that have come before us, including this one, have been set aside. Crucially, those 2 typify the worst examples of personal cost orders. And in the 4th matter, where no personal cost order, where there was no personal cost order by the High Court, but there was an insistence that this court should make such an award, we declined the invitation.
So there was an insistence by the respondent institution.
Yes. Well, it's saying there were 4 cases basically. Only in one was, which was the Reserve Bank case, I think. And then he says in 2 of them, they rejected those personal orders because he says that they were the worst form of personal orders of the automatic knee-jerk type of court order. Then in the 4th one, he says it was not sought in the High Court, but in the Con Court, there was an insistence by the respondent. And as he puts it politely, the Constitutional Court declined that invitation.
So exactly that the respondent institution tries to use the courts to punish the public protector, which goes against all our principles.
Yeah, well, that's the conundrum, isn't it? That's the central conundrum of this particular inquiry. That this parliament is now an extension, or at least the intended extension of those who are affected by the public protector. Because it might not be clear to others, but the chain reaction is like this. The public protector investigates, let's say, a multi-billionaire called Mr. Ngola. And that multi-billionaire is then going to use their deep pockets to fight the public protector in court, right? Because how dare she wants to investigate him. The court, if it falls into the trap that Matlanga J is talking about, will automatically give that knee-jerk cost order for her to be bankrupted and pay the personal costs, right? In doing so, that court has to justify that. And then it comes with what he calls unjustified nouns and epithets to describe her conduct, because it has to justify why it must give the costs, right? Then it's going to say, no, she's the worst person who has ever lived, and therefore she must be mulcted with the costs. Issue a judgment, right? And then Parliament says, Ms. Mazzoni in particular, not Parliament. Ms. Mazzoni says, there's this scathing judgment, takes it to Parliament. The rest of anybody who doesn't like the public protector says, yeah, well, let's chop her head and take that judgment because, quote unquote, it's binding, and then it's the basis for impeachment. Then the reaction, which is exactly what is happening here. That's why I said to you, 90% of the charges here are based on this cost, on these utterances of the courts and the cost orders. You testified yesterday very clearly and unambiguously that the Parliament should not allow itself to be, the whip, as it were, when the arm and the hand actually belong to all sorts of other people, and the Parliament is just taking a judgment and imposing it on a process like this for an impeachment. Can you please just talk to us as South Africans or this Parliament about the dangers inherent in this? And maybe to the continent, because it's not, as you said, these are not things that should be copied by other people. Taking into account what we've, the quotations that I've given you from the Constitutional Court.
I think maybe just to put it very simply, the legislature and the judiciary should not be used as enforcement mechanisms on behalf of the executive. The judgments that have been issued are mostly between the public protector and the executive. And once these judgments come out against the public protector, if they're then taken up by the legislature as a justification for any disciplinary procedure against the ombudsman, it means that the executive has managed to get their back at the ombudsman, firstly through the judiciary, but the judiciary are allowed to review the reports of the ombudsman and to stop at that, to either reverse, uphold, and then it should end at that. The public protector should then look at it and say, okay, I have to change my work ethic, my work style, and the way I report and the way I investigate. But then if the judiciary again punish the ombudsman by issuing personal cost awards, and then those reports, the judgments again lifted by the legislature, the respondents and the complainants are allowed to complain if the officer of the ombudsman is not performing optimally, and they can use the courts of law. But for the three arms of government to start to also become complainants in the process where the ombudsman has not misconducted herself in any way. I think it's really put the institution of the ombudsman under threat. And I would want that, you know, a healthy discussion is held around this matter in various jurisdictions by all three branches of government. They all have to understand what they're putting in, what their stake is in this institution, so that this sort of issue never arises again. It takes us so much back, as I said.
All right. Now, I'm sure that, well, as I said yesterday, at least some of the people who are taking us back like that probably is it's not intentional, although some of them, it might be. There are many ways in which who are sought to be taken back in this country. But finally, I want to take you through, because of time, we won't be able to go through your slide presentation, but it's at page 272. I'm just going to highlight 2 or 3 of the slides, just to wrap up really what we have discussed in the past 2 days. Thank you. Chair, the witness had prepared the slide presentation, and at some stage I thought we would follow it but we decided to follow the statement rather. So, but it's available to the members. Okay, slide 1 and 2 are just I think we've covered that. Slide 2. You say that the ombudsman institutions have become a crucial component of the contemporary model of good governance. They are crucial in protecting and promoting administrative rights and giving people a way to file complaints free of charge when such rights are allegedly violated. So that's the broad mandate. The emphasis there is on the fact that the services are free, unlike the courts, which are not accessible to the poor. And then the next slide, you can jump. Next one can jump, next one can jump. And then 278, there is just a summary of what you call the comparison between the classical model, which you say is to be found in places like Zambia, Malawi, and the hybrid model, which is to find in places like South Africa, Uganda, Nigeria, and Zimbabwe.
Yes.
And Namibia. Namibia is also a dual mandate. Next one, 279. And this is the typical conundrum. The office is in a difficult situation because it needs to use the government's resources while at the same time checking on the same government.
Yes.
And you say, nevertheless, the independence, where it is again, from other governmental branches is likely the most crucial condition for a successful ombudsman's office. And that would also entail issues such as the institutional immunity and autonomy.
Yes, exactly.
So that means this process really suffers two major flaws, to put it bluntly, in that it's this issue of taking judgments and using them, which you just spoke about, but also the other issue of breaching the protocols on institutional autonomy.
Yes.
All right. And natural justice we've spoken about. Next slide, you can jump. 281, just for the sake of emphasis, your third bullet point highlights the autonomy and independence of the Ombudsman's office.
Correct.
All right. Then you go to the instruments. We won't do that because we've dealt with most of them. You deal with the AWOC, the role of ALJAMA, those principles of, on the next slide, the quest to take this to the AU and all that. And the role of the South African government in the establishment of such institutions. 284. Deal with the security of tenure and natural justice again. To 87. Yeah. Okay. There you deal with the Venice principles and you highlight the immunity from legal process in respect of activities carried out in their official capacity. Do you want to add anything to that? Or its importance?
Really, I think what I should state here that the option to have a matter taken to court against the ombudsman should relate only to the findings and recommendation of the ombudsman. That is also what the court should address itself to. And once the judgment comes out, it is a tool for the ombudsman to use to improve the performance of the office.
Okay, thank you. Next, 288. Those are the Paris principles, which is one of those instruments. 289 is the UN. We've covered that. 290, the issue of the UN. Again, your last sentence there goes back to your original point about the protection and promotion of human rights. 91 to 92. Right. And then I think this is your last slide at 292.1. Yeah. And I think it covers for me what I really would like us to take this discussion to. which is the question that you posed there. Who is the ombudsman's ombudsman? In other words, who shall protect the public protector? If Parliament, the judiciary, and the executive, in the way that we have now described, become a chain of punishment, a continuum and a continuous chain. And by the way, maybe let's pause there. In your speech, you refer to something that you call the party whip system. So political parties are also able to abuse the public protector, correct?
Yes, according to that particular example in the Lost at Sea case.
Yes. And no, because here we have, well, political parties that one, as I said, I told you there's one that was had a vendetta against the public protector even before she started work. But you talk there specifically about the ruling party, which obviously would wield a sufficient majority to do as it likes, basically, in the parliamentary system. So if we have all those weaknesses and the continuum of punishment, as I've termed it, then who's going to protect the public protector? And I think that's the profound question on which you end this. And I just wanted to ask you, maybe if you don't, there's one place where I'll propose an amendment to your slide there, or an expansion. So that's why I'm taking you to that slide. So if you go through the bullet points, you said appointment and accountability to the legislature and protection of the office. So you agree that the real ombudsman of the ombudsman should be this parliament?
Yes. The investigation mandate covers the executive. Once the investigations have been carried out, special reports are submitted to Parliament. But however, even in its operation, if the Office of the Ombudsman has difficulties, they should be able, when they are tabling their reports or the annual reports, they should be able to bring out any operational problems, administrative problems, and even legislative issues to the attention of Parliament, so that there is no issue of compromise. Yes. But however, practically speaking, because it is the executive that funds the office of the ombudsman, they often have to have daily interactions with the executive regarding the running of the office. But if there are any problems, it should be directed to the legislature to act sort of like as an arbiter for the office, to speak for the office.
Yes. And if we go back to our example of what I call the continuum of punishment, in the cases that feature in this case, there are members of the executive who feature very prominently, such as Mr. Kodan. In the cases that there are two cases in particular. One is called the so-called rogue unit. The other one is Pillay pension matter. And then there's the infamous CR17 matter, which is one of the charges. That's the one I was talking to you about the alleged bribery to hold office. and then you have a host of SOE entities. So the cases really represent what you are saying, where the executive takes on the public protector, and now it wants this parliament to be its extension, so to speak. What are the dangers in that?
Well, basically, I think it goes down to the independence of the office. The office holder, in a way, accounts to Parliament, and the independence of the office to investigate executive bodies must not be undermined in any way at all by the legislature or by the judiciary. So this is the reason why I said that having brought these standards, these international standards, to the attention of the government at large, I think it would be very, very important to look at the standards and see where the application of these standards falls short, so that some of these issues may be corrected.
Yes. Okay. Very quickly, before the chair now runs out of patience.
Just before we proceed, can we now wrap up?
Thank you, Chair.
Advocate Mbofu.
Yes, thank you, Chair. All right, so I'll just go through the rest of them in point form. So security of tenure and the judiciary, we've dealt with that. Judges' terms and conditions, referring to the judiciary, we've also dealt with that. Powers to issue orders, judiciary and so on. The one that I wanted to contest with you or to debate with you is you say adequate funding for operational and administrative and various interactions. Whether that's really just the executive, or does the legislature not have a major role to play in that as well? Well, obviously the legislature is not going to give you money, but at least in assisting you to lobby, quote unquote, for the...
Yes, definitely. When the office budget is being debated by Parliament, of course, they have the power to increase that budget. Yes, in that sense, yes.
Yeah, good. Okay, so then also the establishment and administrative and operational autonomy, we spoke a lot about that. And you said that that's a function of the executive. But again, I would say that the legislature also has a role to ensure that those lines are not crossed or blurred. Correct?
Yes.
Use of principles of national justices. Well, that goes without saying, and to say that applies to all three branches, including the legislature.
Yes, each and every branch of government, when they're dealing with the ombudsman, they must exercise those principles to ensure that they're doing the right thing. And the ombudsman as well, when they're dealing with the executive as respondent institutions, you have to ensure that you apply the principles of natural justice as your standard. Yes.
And lastly, without talking about it in detail as you did yesterday, it's your what I've called the fundamental thesis of your evidence, which is that if there's a way, we should find a way of going back to the system where the issuing of reports is backed by recommendations only, as opposed to binding remedial action, which, as I said, probably is what has brought us here.
Yes, it protects everybody. It protects the courts. It protects the executive from trying to, influence anybody. It protects the ombudsman, because then there's no one who has any grudge against the office of the ombudsman. The system just works well. It's self-accounting, in other words, but it's a way of using soft power in order to influence the system to ensure that the tenets of good governance are being respected. Yes.
Using more brain than brawn. Okay, well, thank you, Chairperson. I was going to ask you if I had time just to contextualize, but at the end, the Chairperson in any event will give you an opportunity to say anything that doesn't necessarily come from the questions. Thank you, Chair. Those are my questions.
Yes.
Thank you, Advocate Mpofu, and thank you, Ms. Sokoni. We now going to pause for tea break, and we'll be back at 10 to 11.
Thank you.
10 to 12. Thank you.
Recording stopped.
Thank you, colleagues. Hope you had a good, quick tea break. We now resume, and we're going to start the cross-examination. As indicated when we started yesterday, we said that Mkhwebane had the day dedicated to him. He did make a request and he made good to it that he didn't finish yesterday. It's just concluded before tea, and as I indicated thereafter, we'll invite evidence leaders for cross-examination. I am still also indicating that members will come today still. So if we spill over a few minutes or an hour, we'll do that so that we conclude. Mr. Gon has been here. I hope you don't want to be here until tomorrow. Yeah, I know you enjoy Cape Town.
I'm sure we'll finish today.
Sorry, I don't want to be pedantic, but just to remind you, in case, just for the record, that the evidence leaders are not allowed cross-examination, but they can put questions.
Thank you. Well, we're not going to discuss that. Thank you. Advocate Bauer, I now hand over to you.
Good day, Mr. Kony.
Good day.
I just want to understand your evidence. You are the public protector of Zambia, and you come and you give a perspective from a perspective of position, or from the perspective of the public protector. Would that be correct?
From the perspective of public protector, and also from the perspective of the international standards that have been set in place for the Office of the Ombudsman.
And you use those international standards as the benchmark by which you give your evidence, as I understand it.
Yes.
Right. You also, your organization which you represent, have issued statements and have come out in support of the South African Public Protector, correct?
African Ombudsman and Mediators Association has not issued a statement according to my knowledge, but I believe the International Ombudsman Institute must have written a statement in support of the process that is going on now. I'm not very sure, but I suspect the International Ombudsman Institute.
I wasn't going to put the statement up because I didn't think it necessary, but I think Ms. Kajuju can confirm with you that she did issue a statement in support of the Public Protector in June of last year.
Oh, on behalf of the African Ombudsman and Mediators Association?
There is another, sorry?
Because there are two organizations. There's the International Ombudsman Institute and the African Ombudsman and Mediators Association. And I believe Madam Kajuju issued a joint statement with the president of the International Ombudsman Institute. That is the one that I'm aware of, as in her capacity as Africa Director for the International Ombudsman Institute.
Okay, I think during the lunch adjournment, I'll provide you with that statement. I don't want to delay matter because I don't think much turns on it. But the statement which is attached to your affidavit is a statement by the African Ombudsman Mediators Association.
Maybe you could just...
Correct. It is, do you have a hard copy of your affidavit with you? It would be the annexure CCZ2. Yes, put it up, please. It's on the screen.
Yes, this is the statement, yes, that we have just submitted in support of these proceedings. This is the statement you're referring to?
Yes.
Oh, yes, okay. Thank
And
you.
that is attached to an affidavit which you deposed to.
Yes,
Did you prepare the statement?
yes, this statement was prepared by me.
And this was based on your knowledge of the legal principles that's contained in the statement.
Yes,
Right. There was some confusion about whether you have been appointed as a judge, or whether you have not been appointed as a judge. The committee last year was told that you had been appointed as a judge and that it was just a matter of the I's being dotted and the T's being crossed before you would be taking up such office. Can you perhaps clarify this?
thank you very much. Yes, I was appointed to the office of judge and I was awaiting ratification. However, as you well know, the office of ombudsman is supposed to have security of tenure, or it's supposed to be for a term certain. And I had brought this to the attention of the authorities that there was this conflict, that there is a term certain for the office of ombudsman. And they looked at the issue and they looked at the laws, and then they agreed with me that I was supposed to actually finish my term of office as ombudsman before I could be considered for any other appointment.
Okay, so there was no, there's a Judicial Service Commission process in Zambia, am I correct?
Yes, the Judicial Service Commission recommended for my appointment as judge, and then the president appointed on the recommendation of the Judicial Service Commission. And then the matter was sent for ratification to Parliament.
And was it ratified, or is it in between that it was?
Before the ratification process could be completed, the matter was brought to the attention of the authorities.
Now, can you maybe explain to the committee, what are you an expert on?
I beg your pardon?
Can you explain to the committee, what are you an expert on?
I have come to address this committee on the aspects of ombudsmanship. I've been an ombudsman for 18 years. This is the 19th year, actually.
And in those 19 years, how many instances or involvements have you had in the removals of public protectors via constitution and legislative process such as this one?
I have had occasion to look at aspects of ombudsman offices under threat. As a member of the Executive Committee of African Ombudsman and Mediators Association, and also as the director of the International Ombudsman Institute, but not to the extent that of the South African process, where there is an actual involvement of an international organization. Yes. But we have considered such matters at board level, either the IOI or the African Ombudsman and Mediators Association.
So can we just limit this to removal proceedings such as this nature? We accept that you've been an ombudsman for many years. And let's distinguish between what is under threat and the removal process. How many such removal processes have you been involved with?
As I have said before, in removal processes, no. But where ombudsman offices are under threat, yes. I'm just distinguishing.
So the proposition was put to Mr. Hassan Ibrahim, who's a who's an experienced South African constitutional lawyer with a South African law degree and an experience of some 20, 25 years in constitution and constitution making, that he was not an expert in the removal proceedings of public protectors or ombudspersons. Would you regard yourself to be an expert in the removal proceedings of public protectors?
I would consider myself as an expert in ombudsmanship, and I think ombudsmanship would include any other issues that are incidental. So it is just an issue of applying the principles to any situation that affects an ombudsman.
So he told the committee that it was a relatively new area, that there hadn't been such formal proceedings of removal processes pursuant to a constitutional and legislative framework, and that one wouldn't find a jurisprudence in respect thereof. Would you agree with that?
I wouldn't be able to say yes or no, but because ombudspersons all over the world, it's not all of them who serve their full terms. Some are removed, some even forcefully removed from office. However, I couldn't off the cuff give you any cases regarding removal of ombudspersons.
You see, I think we were in agreement that this is a novel process. And so we searched high and low for purposes of assisting the committee to see if there was some, as lawyers, you look for a precedent to see how you can be guided by a similar like process. And the closest we came was a process that took place in Philippines that got aborted before it was completed. So my question to you is, in the removal of public protectors in the world that you would be aware of, or your international organization would be aware of with your some 100 members, are you aware of any case law being reported or any process through a parliament of an impeachment process of a public protector?
Maybe let me put it like this. I think that if the principles of ombudsmanship are being followed and are being applied strictly, there wouldn't really be a similar process found anywhere, unless it is a situation where the ombudsman has, like I said, grossly misconducted themselves, the ombudsman himself. And for you to appoint an ombudsperson, you have to have gone through a very careful vetting process. So I would not expect that there would be several cases of impeachment of an ombudsperson, really, considering the type of office that it is.
Mr. Mkhwebane, I accept that if you play by the rules, you shouldn't get impeached. But the converse is also true, that if you don't play by the rules, you may be subject to impeachment as a general proposition. Would you agree with that?
Yes, as a general proposition.
As a general proposition. Now, at the level of the question I'm asking you is, are you aware of any public protector anywhere in the world where the legislature, as the oversight body of public protectors, has made a call that you are going to face impeachment proceedings because, and let's put this colloquially, you haven't played by the rule, and whichever national standard you had to meet as a public protector, you didn't meet? Are you aware of any process of that nature that has occurred?
To the level of the process that is going on here in South Africa, no.
Okay.
So, to the level of the process that's going on here in South Africa, there wouldn't be an expert on this process anyway, because you're not even aware of such a process having occurred anywhere else. We're not talking about the levels of generality of threats or the levels of generality of the standards by which ombuds people are protected. We're talking about the actual impeachment process.
I would say that I am not an expert in South African law. I'm not an expert in South African constitutional law, but I can speak knowledgeably on matters of ombudsmanship. So what the process that is going on here in South Africa is unique to South Africa because of the way the constitution has been crafted and the way the laws have been put together. So I wouldn't say I'm an expert on the process that is going on here in South Africa. I can only speak to the general principles of ombudsmanship.
Thank you. So, and I fully accept this. And you're a trained lawyer and you can read a case and you can read legislation. Can we accept that? You'd be able to look at the law and be able to explain it and you'd be able to read a case and you'd be able to understand the judgment.
Yes, I am a lawyer.
No, I'm wanting to make it clear that I'm not questioning that for any moment.
Okay.
Okay. So I'm not trying to say you can't do that. You can look at South African laws and you can look at South African cases and you can form an opinion on it, even though you're not an expert on South African law. Would you agree with that?
Well, yes, but I wouldn't be able to give, for example, the sort of evidence, the level of sort of evidence that Mr. Ibrahim gave, because he has studied South African constitutional law and he's able to give his opinion on the constitution of South Africa and the constitutional processes of South Africa. So I don't think we can be equated really.
And I noted that when you answered some of Advocate Mpofu's questions, you prefaced it by saying in a classical system. And your Zambian experience is a classical system, correct?
Before, it was not a classical ombudsman system because we were an executive ombudsman and we were answerable to the executive. We only became a classical ombudsman system from 2016. But again, of course, with the fact that we now have binding powers, which again, I cannot say. Yeah.
So we accept that South Africa is not a classical ombudsman. It is not answerable to the executive. It's answerable to the legislature. Correct?
Yes.
And then the post-2016 Zambian experience is a classical one, but the South African system is a hybrid one.
It's a hybrid one because it has a double mandate.
That's right. Okay. Now, and were you integrally involved in the Zambian changes from an executive to a legislative process that occurred in 2016?
Yes, I was.
So, can I maybe ask you this question? You're not an expert in South African constitutional law, and you're not an expert in the application of South African law, right? And as I understand, you testified that your reasons for coming to testify here is about protecting of an institution in South Africa that can't be allowed to go backwards, and it's an institution which is informed by a constitution and provisions of the Public Protector Act, which is almost an example for other countries. Would that be a fair summation of the reason you gave for why you came to testify here?
Yes, I said the reason why I came to testify here is because after 18 years as ombudsman, the institution of the ombudsman in Africa has made great strides. And for me, it was important that I come here as well and try to also contribute to ensure that the institution of the Ombudsman continues to make progressive strides.
Indeed. And this was done pursuant to a letter that was addressed to the organization by the Public Protector's Attorneys, which is 214. It was addressed to the Secretary General of ALJAMA and the African Regional President of IOI. Correct? You received the letter on the 23rd of August, it's 214, annexed to the affidavit. And the organization's assistance was sought, and I quote from paragraph 2 while it's being put up on the screen, because I'm sure you're aware of this. You might be aware of the fact that the process underway is the first of its kind and unique in the sense that there's no precedence thereof. As a result, it is of paramount importance, I'm reading paragraph 2, that the public as well as the committee tasked with this function must fully understand the role played by the office of the Ombudsman within a constitutional democracy. Correct?
Yes.
Right.
Yes.
And that's the purpose for which you've come to give evidence, to assist the committee in understanding the role played by the office of the Ombudsman in a constitutional democracy. Would that be fair?
Yes.
And in the letter on page 213, you were nominated. It's just a page, 2 pages before that. Yeah, 1 page before that. You, in fact, were nominated by the organization to make a presentation before the parliamentary inquiry. Correct?
That is correct.
And that is the presentation. Am I correct in assuming that that is the presentation that Advocate Mpofu took you to near the end of your evidence?
Yes, that is correct.
Right. And you prepared that presentation?
That is correct.
And they say this followed your observations of the inquiry of the proceedings from the 24th to the 31st of July on behalf of ALJAMA. Right. Can you tell us how ALJAMA came to be in the proceedings on the 24th? I'm not sure if you were here all 6 days, but I can't remember. But the letter says you were here from the 24th to the 31st.
Repeat the question, please.
How did it come about that you came to be observers to the parliamentary process from the 24th to the 31st of July?
There was an executive committee meeting which was held in African Ombudsman and Mediators Association executive committee meeting where it was decided that there should be an observer team sent to come and first observe.
Right. And what was the purpose of that?
The purpose of
the observation that you were coming to observe?
We had received, I believe, we had received a letter from the public protector. I'm not very sure. The secretary to general to ALJAMA would be able to answer that question. But I think there must have been a letter received from the South African public protector requesting for our intervention, and I think that was the reason why this matter came up before the executive committee of the African Ombudsman and Mediators Association.
And is the South African public protector part of that executive?
She is part of that executive, but I believe she was not at that particular meeting. She was not at that particular meeting.
And what was the nature of this intervention that was sought?
She didn't ask for a specific intervention. She just wrote about the process, and she was unhappy about it, and she sought intervention of the African Ombudsman and Mediators Association. I think that was following her request even to the International Ombudsman Institute. I'm not very sure, but
in the course of your evidence, you testified that there are standards that public protectors should adhere to, and natural justice and procedural fairness are included in those standards. Correct?
yes, both of the principles that really guide and protect the office. So whenever you're dealing with a complainant, with the complainant comes before you, you find out what the complaint is, whether the principles of natural justice were applied, were they heard, were they given an opportunity to present their case. And then when we go and investigate again with the respondent institution, that is the guidance that we use. And then when we, even internally, when we are dealing with our members of staff, we always try to ensure that we give everybody a fair hearing, because we should be the example par excellence. We should ensure that we are leading by example all other institutions.
And maybe if I could paraphrase what I think you were saying, that the office holder of the public protector must exhibit the highest tenets of integrity, professionalism, transparency, and accountability to the public interest, the cause of justice, the Constitution, the rule of law, and democratic principles. Would you agree with that?
That is correct.
Right. And they must also assist with the maintenance of law in the country.